Good day, Crime Talk aficionados. We have a short show for you today because of the inefficiencies of the court system today. First on the docket, we have a Delphi update, our segment of This Day in Legal History, and our Dumb Criminal of the Day. Let's talk about it.
All right, lawyer.
Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. Okay, I said in the intro, it was one of those days. Yes, I had two quick matters set in Denver this morning, and it was kind of nice as I was walking out and rushing to another court hearing on the other side of town. Somebody came out, I think she was a potential juror in her case, and said, "Hey, I really enjoy your podcast." That kind of made my day. And I said, well, it's tough when I'm stuck in court all day. This is another reason why all courts should be online so everybody can see what is going on. Most inefficient day I've seen in a long, long time. I literally had to have another attorney from my office come stand in and do a plea. I was there at 8:15 this morning and I left at 12:30 and it still wasn't done. Not to complain, I'll just let you know, ladies and gentlemen, the court dockets are completely overrun. And what is really slowing it down is there is a slew of Spanish-speaking cases. Now, yes, everybody should have a right to understand what's going on, but the courts should have interpreters in the courtroom so that they can do it contemporaneously versus calling in on a language line, which slows everything down tremendously. Just something to think about, not complaining, just the reality of it. And then I had to go to another part of town, and guess what? We had to wait for an interpreter to show up. It's been one of those days. All right, let's go ahead and get to it. Listen, if you haven't done so already, please go to crimetalksearch.com. You can sign up for that background subscription service. And when you do, you are able to do a background search on as many people as your heart desires. Hell, you could even do one on me if you wanted to. And you'll find out all types of things on the people that you do a background search. It even has this report sent to you literally while you wait. All right. And you're going to find out information on whether people, where they live, what are some of their social media accounts, email addresses that are associated with this particular person. Do they have judgments? Do they have liens against them? Do they have a criminal history? Do they have anything in their background that would say, hey, maybe I should question this guy a little bit, or gal, so to speak? Do they want them in your life? CrimeTalkSearch.com. You'll be happy you did. Remember, you can cancel at any time. So whether you want to do one search or 1,000 searches, it's all the same price. All right, let's go ahead and open the record for Monday, November 4th. And let's get to it. First, a Delphi update. Now, obviously, the crux of the prosecution's case in the Delphi murder is that the suspect, Richard Allen, confessed in custody. He confessed on the phone. He confessed to jailhouse personnel. He confessed to his psychologist. And now the defense is going back up and cleaning things up to show what he said was simply not true. And therefore, you can't trust the confession by Richard Allen. So day 15, ladies and gentlemen, day 15 of the Delphi murder trial. And for those who don't know, Richard Allen is charged with the murder of Libby German and Abigail Williams back in February of 2017. Those two young girls were found deceased near the Monad High Bridge there in Delphi, Indiana. Now, Allen was first investigated back in 2017 and then again in October of 2022. After a second police interview was conducted, after the FBI basically lost his first interview, they misfiled it, and therefore they didn't know about it for some 5 years. Crack government team on the case for sure. Anyway, the trial began on October 18th and was expected to go through mid-November. Originally, 16 Allen County residents were sat as a jury in this case, and one juror was dismissed on October 25th. Now, there are no cameras in the courtroom, and frankly, I'm not sure the prosecution want the cameras in there. Some of these things are a little embarrassing for sure, just as to the level of the lack of investigation or the poor investigation. And I'm not sure the judge wants the people to see what's really taking place. Anyway, so what happened today? First, the jury came back in the afternoon, and the defense attorney called Jamie Jones. Now, this is Richard Allen's half-sister, and she tells the jury that she is 5 years older than Richard Allen, and obviously they lived together throughout their childhood. She says that Alan got married right after getting back from being in the military. And Miss Jones states that Alan did never touched her inappropriately or molested her in any way. And she was asked, would you lie for your brother? She says, no. Why is that significant, right? Some of the confessions were that he had done something inappropriate with his sister and even his own daughter, ladies and gentlemen. So the defense really has to show that this just simply is not true. Then the defense called Brittany Zapata, Zapanta. That's Richard Allen's daughter. Now, Allen is reportedly nodding his head as she takes the stand. And Miss Zapata tells the jury that she moved out in 2015 for a job, and she says she works in an urgent care facility. She attended Ball State University and then went to Indianapolis. Asked point blank, Miss Zapata, did your father molest you? No. Would you lie for him? No. The defendant finishes the direct examination of her. Rather short, rather sweet. That's the best thing about being in the defense. Get your witness up, you get him down, you ask a couple of questions before they can say anything wrong. All right? Anyway, Ms. Zapata was asked by the prosecution if Mr. Allen had changed her appearance in any way after she left for Ball State. She says no. He asked another question about Allen's height and weight. The defense objects from the prosecution question, and he shows Ms. Zapata photos of Allen. The prosecutor asks the attorneys asked to approach the bench. And after the sidebar, the prosecutor shows Zapata more photos and asks if certain photos look like her dad back in 2017. She said yes. The gallery did not get to see the photos. Now, the defense objects and says the photos are outside the scope of questioning, and there is another sidebar, and the judge sustains that objection. The defense also called a woman by the name of Shelby Hicks. Hicks says that she is a realtor. She was 23 years old back in 2017, and she tells the jury on February 13th of 2017, she took her car in for repair and went for a hike with her boyfriend. She says that they got to the trail about 2:30 p.m. and parked in a connector lot, and the defense attorney, Andrew Baldwin, is trying to get her to say the Mears entrance. Now, Baldwin asks her if there's anyone parked there other than her. She says there were other cars. Hicks says that they walked towards the highway for about 5 minutes and then went towards the bridge. She tells the jury it takes 10 to 15 minutes to get to the bridge, and she said she saw an older gentleman, 2 girls from school, and a few other kids. Hicks says that she saw an older gentleman with a camera and saw Cheyenne and Shelby Duncan from school, and she tells the jury she was there first on the bridge's platform. She said she did say hi to her friends from high school, and Ms. Hicks tells the jury that she was on the platform for between 15 to 20 minutes and went back to her car with her boyfriend. She tells the jury she did not remember if there were other cars there when she left. Now, Hicks says the next day her boyfriend Daniel wanted to tell law enforcement what they had seen, and she says they went to the police but were asked to come back at another time, and they went back that evening. Hicks tells the jury she did not hear anything on the bridge, and she says she met with law enforcement twice, first in February of 2017 and then again in March of 2017, and she says the police never took her phone to extract data. Then the prosecuting attorney begins her cross-examination, and Ms. Hicks says her cellular provider back in 2017 was Sprint, and she tells the jury she never walked across the Monon High Bridge. She does say that on that day she left the platform before her friends returned. Now, the jury had a couple of questions. The question was the man with the camera old? Hicks says yes. Did you arrive at the bridge at 2:55? Hicks said it could have been. At 2:29 p.m., the defense calls Steve Mullins. The defense shows Mullins a list of Ford Focus SEs in white, registered in Cass, Carroll, and Tippecanoe County between 2011 and 2017. Now, Baldwin says he only focused on the cars that were similar to Allen's, and the prosecutors object, saying it was not certified. Baldwin asked how many people owned similar hatchback models in Carroll County in the surrounding area in 2017, and Mr. Mullins says he didn't know. Baldwin says Mullins created a log of missing interviews. He said on March 18th that Mullins did not say that at the hearing in March. Baldwin raises his voice, then apologizes to the judge. Now, Mullins looks at the transcript from March hearing. He admits that at the time there was no log. He tells the jury there is a log in the filing cabinets from early on and says he's gone through the cabinets and found it since he testified in March. Baldwin then asks about Libby's phone. Prosecutor then asks for a sidebar. Baldwin says Dr. Walla was a fan of the Delphi sites and asked if it would be important to find out if a van was discussed on social media. Mullen said, I don't know, I didn't look. Baldwin says there was many mentions of a van on social media, and he says Mullen does not know what Walla said when she was taking care of Mr. Allen. The jury asked the question, why would anyone discuss a van prior to Allen's confession? Mullen says that's why we looked into this, that this was the first we had heard of it. Baldwin asks Mullen if there was ever heard of a white van 30 minutes outside of Delphi with a suspicious thin man asking kids if they wanted candy. Mullen says he doesn't recall. The defense then called a gentleman by the name of Brad Weber. Baldwin asked him why he was upset when they talked before. Mr. Weber says, I was upset because you were trying to tell me what I did when I got off work. Baldwin handed him a transcript from an FBI interview Weber did in February of 2017, and Weber tells the jury he went on a 3-day trip to Arizona and got back Sunday before the girls died. Baldwin asked him about his ATM machine business. Weber says that he makes money off of them through surcharges, and he knows how many he had in 2017. He says he has 30, and at one point he now only has 15. Weber tells the jury he attended to his ATM business machines daily, says he checks how much money they have and gets money from the bank. He says he doesn't know what bank he used in 2017. He thinks it was Regions Bank. Well, Weber says his ATMs are at a gas station, tavern, restaurant, etc. And he said that he used a black Subaru to drive to service his ATMs. And he says he uses Regions Bank now, but not always at the same branch. He says one day of the murders, he went straight home from his other job at a Subaru plant. Now, Mr. Weber tells the jury that nobody from law enforcement asked him to go to the police station this past August, that they asked him to go to a different location. And he says it could have been Steve Mullen that called saying, the only time I used my van was when I was pulling a trailer. Now, Weber says he took a nap when he got home and work on February 13th of 2017, got up about 5 p.m., and someone knocked on the door. Baldwin asked, do trespassers come onto your property? Weber says yes. Weber says, did he not hear any screaming that day? He said, had a home in Lafayette in 2017, and he owns a trailer. Now, Weber then tells the jury he gave law enforcement permission to go inside his house, but it was not on February 13th of 2017. He says his van was in the grass and the Subaru was in the driveway. Now, Baldwin hands him a photo of his garage from February 19th of 2017, and the prosecutor objects. The judge admits the photo over objection. The prosecutors then do a cross-examination of Mr. Weber, and Ms. Weber says that law enforcement stopped him on his way home a few times, probably in February of 2017, and he says someone looked through his property on February 13th, and he confirmed he talked to law enforcement on February 17th, and he went straight home from work on the February 13th. The jury then asked questions. Do you know if the ATMs would have photos or video servicing? Weber says not the actual ATMs, but some of the locations do. How far in advance would you have to order cash for ATMs? Weber says that getting cash isn't a problem, but a week in advance. What is the process to clock out of work? What driveway do you use at home? Driveways under the Monon High Bridge. Do you drive under the bridge? Would you have taken that route on February 13th? And Weber responded, yes. Do you typically go home before servicing your ATMs? He says no. So the jury then left the courtroom after that, and the defense said they had some more questions of Mr. Baldwin, saying that they have an offer of proof for a third-party suspects. He asks if Mr. Allen asked police if my spit was on one of those girls. The judge, Gull, then tells the defense, we've had this discussion 1,000 times. You have no evidence to tie these people to the crime. Well, they're clearly trying to tie Mr. Webster to the crime. Anyway, Baldwin says he has an offer of proof for the third suspect. He asks, once again, if Allen had asked police if my spit was on the girls. Judge Galls tells the defense, once again, we've had this discussion 1,000 times. There's nothing. There's no nexus. Move on. You're not getting your third-party suspects in this particular case. Now, there was also testimony regarding footage from inside Richard Allen's cell. The defense called an individual by the name of Max Baker to set the videos. He said the security camera video from inside Allen's cell does have timestamps, and the courtroom TV again was turned to face away from the gallery, only visible to the jury. Now, Baker told the jury he created the video by piecing together smaller parts of his cell footage And video 1 was from April 12th of 2023 and included clips from a 5-hour time period. Video 2 was from May 25th over a 12-hour time period. It was noted that video 1 was an hour and 20 minutes long, and multiple jurors took notes while watching the video. An alternate juror, apparently who Russell said was a high school-aged daughter, raised his eyebrows throughout. Now, the prosecutors and defense attorneys were apparently gathering around to watch this footage. Video number 2 was 26 minutes long, and many jurors were watching, and they were looking at Allen as they were watching this video. The defense also called Dr. Polly Westcott. She is a neuropsychologist based in Carmel, and she told the court her specialty was in forensic psychology and neuropsychology. Baldwin and the defense attorney, Brad Rozzi, hired Westcott back in May of 2023 to assess Mr. Allen's emotional and physical health while it was declining when he was in the Westerville facility. Miss Westcott, Dr. Westcott, was given access to Allen's mental health treatment records, video footage from the prison, and access to his recorded calls. Now, she told the jury she received more information about Allen than she had in any other criminal case that she's worked before, and noted that Westcott stopped receiving videos from Allen back in March of 2024. She met with Allen in Westerville in August of 2023 and performed an assessment of him over a 2-day period. Spoke with his wife, Kathy, for additional information. Her report was 127 pages long. To jump to the assessment, Allen has a long history of mental health issues. Allen was not faking or exaggerating symptoms. Allen is slower to understand process and responds to things. Allen's experienced a complete mental health decrease in the Westville facility, and Allen has major depressive disorder and slipped into psychosis due to stress. Allen's brain chemistry was in fact changed while in prison due to no contact with family and friends. The attorneys showed Dr. Westcott Allen's writing samples she previously reviewed, including a letter he wrote asking for assistance from the court back in November of 2022, and a letter that he wrote to Kathy before incarceration. Prosecution objected to admitting the letters, calling them hearsay. Judge Gold requested a sidebar and later admitted the writing samples after redacting a few words. Dr. Westcott said the November 2022 sample was organized and well thought out, but the letter structure from a later sample was completely different and fragmented. And after reviewing the samples, Westcott continued discussing her evaluations of Richard Allen. She said she gave him an MCI, or mild cognitive impairment test, which is a comprehensive test for personality features and mental health disorders. The test also evaluated if Allen was faking his symptoms. The jurors had some questions for the good doctor. If Mr. Allen has the common sense to be afraid to leave his cell, would he have had common sense to fake his symptoms? Ms. Westcott said Allen's statements about being afraid was before his psychotic episode. Question, if he was depressed as a child, would that cause him to commit crime as an adult? Westcott said not always, and that it depends on the personality type. Would depression as a child cause them to become a sex addict? Ms. Westcott said no. And did you watch Allen's police interview from October of 2022? The doctor said she said yes. So, like I said, it was a busy day in court. That is a quick recap of it. A lot of stuff going on. It'd be a lot easier if we could just all watch the video. Next on the docket, this day in legal history. On November 4th, 1646, going back a little bit of ways, 1646, the Massachusetts General Court approved a law requiring all members of the colony to recognize the Bible as the Word of God under penalty of death. Yes, that's right. Otherwise, it would be heresy, and you would be found guilty and could possibly be put to death. And then finally, our dumb criminal of the day. Please meet Brian Robert Eckley of Tampa. He was arrested on October 30th and charged with 2 counts of making and placing a destructive device with intent to cause harm. Well, where did he intend to do this, Scott? Where did he intend to do this? Well, he was arrested. Mr. Eckley was arrested for 2 radio-controlled explosive devices that he put in toilets in a casino. That's right. These 2 counts are placing destructive devices with the intent to cause harm. Apparently, he would hide from law enforcement while he was doing all this, and an investigation began back in September of this year after the suspect allegedly hid the devices inside 2 restrooms in local casinos. Now, employees found the devices before they could cause any damage. Now, according to the arrest warrant, these devices posed a serious risk of bodily injury to anyone in the vicinity had the devices been detonated. Anyway, they learned a few days earlier a man was behaving suspiciously at the casino, and the man was seen driving a white Ford Explorer. And after lengthy interviews and analytical work, investigators traced it back to Mr. Eckley. Apparently, days before planting the explosive devices, Mr. Eckley was arrested by the Hillsborough County Sheriff's Office in an unrelated case of aggravated assault with a firearm. Anyway, Mr. Eckley was booked into the jail, and he is on pretrial detention. He has a hearing scheduled for November 5th. Mr. Eckley, you are a dumb criminal of the day. Why would you want to blow up somebody using the restroom facilities at a casino in Florida? Doesn't make any sense to me, ladies and gentlemen. But Mr. Eckley, you are a dumb criminal of the day. All right, ladies and gentlemen, that's all we have for you today. Sorry, not in the Crime Talk studios. Have a wonderful day. We'll see you next time. And remember, the Constitution matters.